Hello and welcome to the latest in a series of briefings from Kuits solicitors in Manchester. I'm Robert Levy, the executive partner of Kuits, and today I'm joined by Andrew Weinberg, who is a litigation partner specialising in leasehold property litigation. Andrew, welcome.
Good afternoon.
When we locked down back in March, the government brought in a series of measures to protect businesses that were facing unprecedented problems. And one of them was a moratorium against enforcement by landlords or against failure to pay rent. And originally that was intended to be protection for 1 quarter only, wasn't it? What happened since then?
Well, you're absolutely right. They thought 3 months would be enough. Who knows what's going to happen at the end of that period? Come the end of June, they decided to extend it for a further 3 months, a second quarter, up until the end of this month. And then end of last week, they've decided to extend it to the end of the year. So that's where we're at now. Landlords can't enforce, can't also use the official bailiff regime before they issue proceedings.
So obviously they can't then use the normal procedure if a tenant fails to pay rent. Is there anything else they can do?
Yes, there's only one route available from the legal perspective, and that is they can sue them. They can issue proceedings for non-payment of rent, which is a debt claim, in the High Court or the County Court, depending on how much they owe.
And are landlords choosing to go that route?
Yes, we're starting to see that now. At the beginning, in June, the decision was very simple. Most people were saying, well, let's wait and see, we'll talk, and we'll see how this pans out. As we were going towards September, we've started to see more proceedings being issued, and now I think there will be a significant increase because the landlords have pressures as well, and that's what doesn't seem to be appreciated.
So the protection was very one-sided. I've seen a lot of talk in the press about landlords associations being very much up in arms because it was a blunt instrument, wasn't it? The moratorium. It didn't segment between tenants who genuinely couldn't pay, such as leisure operators and people whose businesses were closed, on the one hand, and businesses which might be thriving on the other.
And that is precisely the problem. You're right, it was a blunt instrument, no finesse whatsoever. And the government encouraged a code of practice to be implemented, which came in sometime late June. And the idea being that parties would exchange information so that the landlord would have the assurance that the tenant wasn't just stringing them along, and they'd show them their accounts, they'd provide them with other financial information so that they could see the picture and make a decision based on that. Unfortunately, some tenants aren't engaging and not providing that information, and it is a voluntary code, so there's no sanction for someone who doesn't engage.
Presumably, you would always encourage a landlord client to open a channel of communication with a tenant to see what other ways there might be of reaching a mutually acceptable solution, like switching to monthly rent, or maybe renegotiating break clauses, or whatever it might be. But if they're not able to reach that sort of settlement, and if they decide to take action in the courts through the normal debt recovery process, are the courts being sympathetic to them?
Well, there haven't been many recorded cases. In fact, I've seen no articles on this or anything at all, and there's been nothing in the press. However, my opinion, based on my long experience in dealing with this sort of matters and knowing the judiciary, is that provided the landlord can demonstrate they've tried to engage and they've done all the things you just mentioned at the outset, I do not think there will be a great deal of sympathy for the tenant that has the funds and has chosen to utilize this process as a form of extended credit. And I don't see the court helping them. What I do think is that the landlord who says, I want to sue you, and doesn't engage may find the court exercising the discretion it has to simply stay the proceedings because of the underlying COVID situation.
So it's part of the tactic for landlord clients that you're representing to get themselves noticed, to get themselves taken seriously by tenants who are just happily throwing back the moratorium and saying, you know, it's your problem, not our problem. Is this partly about he who shouts loudest gets dealt with?
As long as the tenant has the wherewithal, and you believe they have, that is pretty much exactly the situation, because it is that some of these are large outfits, well-known chains. They know how to play the game, and they will have a lot of landlords baying. And if you don't, and they'll effectively wait and call your bluff. So sometimes you have to take that decision. A well-known landlord client of mine said, "What else can we do? We've got our lender saying, what are you doing? We've got to do something."
And and do you think the
And they're going
government?
to issue proceedings.
Well, there you are. I mean, uh, that's the threat, and presumably a threat that you're prepared to carry out with a view to obtaining some form of judgment, even if enforcement of that judgment may come later. You're going to be higher up in the pecking order, aren't you?
That you can go ahead and take certain enforcement steps that aren't available without a judgment. And what's more, in most lease cases where it's non-payment of rent, there are very limited defences. It's one of those areas where you could go for the technical knockout of summary judgment
So
and try and short circuit the process.
yeah, that's very helpful. Are you finding a lot of landlords turning to this route? I mean, presumably in desperation, there must be.
We're starting to see far more of it now, and I think following the announcement last week, I think we will see even more of it. We're starting to have those conversations, and it's going to gather momentum. Those, by the way, those that are talking to their tenants, some of the larger outfits who are keeping very close to them, in constant contact, are seeing fairly good returns each quarter on their rent, sort of the 75-80% region, as opposed to some of the major institutional landlords who, among other things, are involved in owning shopping centres, where there could be anywhere between 15 and 30%. So there's a huge difference.
Okay, well, I'm guessing you would encourage anybody who wants to explore this as an option.
Mm.
Speak to you. I know your details are going to come up at the end of this briefing. To speak to you just to explore what might be possible, and you're happy to have calls like that?
Very happy to have those calls. Always happy to talk to people. You never know what can come out of the conversation. Maybe I can give them a steer that will point them in the right direction. And if not, and we need to take it further, we're happy to help.
Andrew, thank you. That's very comprehensive, and I hope that that's been helpful to anyone who's listened to this. And until next time, thank you for joining us.